Okay, Sonny Slaughter is a law enforcement instructor and Bridget Williams, trial attorney, former prosecutor. Welcome to the show, ladies. How are you doing?
Good.
Doing
Good to
well,
see you,
thank
Bob.
you.
Happy New Year. Happy New
Yeah.
Year, Bridget.
Happy New Year
Happy
to
New
you guys
Year.
as well. Wow, I don't know where to begin, really. I want to jump right into the substance of like the lunacy of that this motion is even happening in the first place. I mean, obviously, if it's factually accurate and the defense proves what it alleges in these affidavits, this is probably, in my estimation, a plus 30 years, the most egregious act of jury tampering that I've seen. And I think it's just more from the standpoint that this is not an unsuspecting, unsophisticated person who made a mistake. This is a person who listens day in and day out to a judge saying nobody should be influencing you. Don't read the papers. Don't do this. Don't do that. And then goes ahead and does it, if in fact it's accurate. But ladies, I was thinking of starting there, but then I had to listen to this argument. And I think our audience may be a little confused, as I was and maybe still am, about what are they arguing about and what is this proffer, Sonny? Let me start with you. What is this proffer they're talking about? And what's clear, the defense lawyer wants to get this alternate juror in to be able to give some information, and the judge right now is saying, well, the juror wasn't involved in the deliberation, so I'm not going to allow that, but maybe if not. What were they wrestling with there?
So when I was listening to this, I was thinking the same. The judge clearly has control of the court. That was the first thing. The other thing is, if the motion and the allegation is that the decision that was made by the jury for the conviction is where the problem came in. Right now, we should focus on that information, that evidence, those facts. And if the alternate juror was not a part of the final decision, then that should probably happen later, if at all. And the judge is really saying, okay, so why are we doing this? And it's really confusing for me, and I think it's probably confusing for the public. Let's get to the facts and what the allegations are related to the conviction that we have, and the individuals that need to have the affidavits acknowledged, need to have what their convictions and things said there. Whatever happened with the alternate juror is not relevant for me, I don't think, at this point.
Yeah, okay, so Bridget, I think that is an excellent summation of essentially what the judge was saying there. But I think the defense lawyer also, at least if I were a judge sitting there listening to it, I'd say, he's talking about preserving appellate rights, not only in state court, but in federal court. And then he used the best line I think that he could have, that the alternate juror can provide testimony that would affect and attack the credibility and impeach the credibility of the court clerk. Work that out a little bit more to our audience about what that literally means.
Okay, so that was the thing that stood out to me, number one, was the fact that the defense attorney is trying to say, well, I want these alternates, the alternate jurors, to come in and provide testimony to say, well, what if one of the jurors who was on the panel, what if they say something that is incorrect, right? What if they say something that is not aligned with what they wrote in their affidavits? Well, then we can use the testimony from one of the alternates who may have heard that same information to go back and say, well, wait a minute, they said X, Y, Z before. So we can use that to impeach their testimony that they're saying here today. And so that's what the defense counsel is trying to say. And the judge is saying, well, wait a minute, I'm not going to rule in a vacuum. He keeps saying those words, but what he's saying is that when that time comes up, then I will assess it. If that does come up, it may not even be an issue. We may not need to bring in somebody to be impeached. But when that time does come up, then I will analyze if I want to bring in an alternate juror. But at this time, I don't want to bring in an alternate juror. I just only want to focus on the people who were on the panel and had some type of direct line with this particular case, not the alternates.
Yeah, ladies, I tell you, it's so funny, depending on the judge you have, what a difference it can make and how this is where you're seeing the power of the judge and how the process goes, because the judge here is saying, I want to wait until the evidence unfolds before I make a decision. I think most judges would say that. But I've seen other judges that said, I want you to lay every single thing out in front of me right now, whether it's relevant or not. Okay, great commentary. We're gonna